First question. Dave is told by his lender that his debt ratio exceeds the limits set by the FHA. Dave was hoping to get financing through the FHA because he has only 5% to put down. On the way to his apartment, Dave sees a sign in the yard that reads rent to own, credit problems okay. Which agreement is best fit for Dave's situation? Is that A, purchase agreement, B, lease with an option to purchase, C, net lease, D, life estate? Okay, we have B and C. You like guess? Okay, see B first. Let's see. All right, and B is a correct answer. So it would be lease with an option to purchase. All right, good job. Question, Russia. Next question. Okay, this is a little bigger. I'm trying to go. There, that works. Colin makes an offer to buy a seller's property and gives the seller $2,000 as earnest money. Before the seller decides to accept the offer, Colin calls the seller and announces that he is withdrawing the offer and asks the seller to return the earnest money. Which statement is true? A, the buyer is entitled to get the earnest money back. B, the seller gets to keep the earnest money. C, the broker gets to keep the earnest money. Or D, the buyer is breaching the contract. All right, so it got A. Okay. Love the participation. A is correct. Good job. The buyer is entitled to get the earnest money back. Okay, next question. Ben is not quite ready to purchase, so he rents a home with the option to purchase after 2 years. This option to purchase is an example of a bilateral contract, B, promise and exchange contract, C, mutual contract, or D, unilateral contract. We got C and D. Okay, so C. Okay, so the correct answer is D. So that would be the unilateral contract. Options are unilateral or one-way contract. So if you see that option to purchase after 2 years, just think unilateral or one-way contract. Okay, next question. Which would a buyer prefer? Land installment contracts or purchase money mortgage? A, land installment contracts. B, either, as both convey legal title. C, purchase money mortgage. Or D, either, as both convey equitable title. This is a tricky one. I feel like I had a similar question on my exam. Okay. Are we saying B? All right, let's see. Okay, so the correct answer is C, purchase money mortgage. All right, so the buyer would prefer a purchase money mortgage. In this agreement, the buyer receives the deed to the property on the day of closing. In the land installment contract, the buyer does not receive the deed until final payment is made. And then a land installment contract transfers only at equitable title. And then a purchase money mortgage does not transfer any title to the buyer. Rather, it is a method by which the seller finances the transaction. So the buyer would prefer a purchase money mortgage in this scenario. That was a tough one. Okay, next question. The basic requirements for an offer include A, subjective intent to contract, B, objective intent, C, both objective intent and subjective intent to contract, or D, neither objective intent nor subjective intent to contract. Okay, so D first. All right, the correct answer is B. So the basic requirements for an offer include objective intent. In an offer, the intent requirement is considered with what a person says or does, which is going to be objective intent, rather than what a person is actually thinking, which is subjective intent. The rule is based on what the reasonable person could interpret as a serious expression of intent. So we want objective intent are the requirements for an offer, the basic requirements for an offer. That was a tough one. Okay. Broker Bruce is working for client Jim, who wanted to buy a lot from Tom. Bruce submits to Tom a purchase and sale agreement. It is signed by Jim and stipulates a price of $25,000, a sales commission of 6%, and closing within 90 days. Tom accepts the price, changes the commission rate to 5%, the closing period to 45 days, initials the changes, then signs and returns the contract to Broker Bruce, who gives it to Jim. Is the contract valid? A, no, the broker's commission is non-negotiable. B, yes, the contract is in writing and signed by both parties. C, yes, Tom initialed his changes. D, no, there was no meeting of the minds. All right, we have D. Correct. Good job. D is correct. There was no meetings of the mind. Well, next question. A homeowner agreed to trade a 4-bedroom, 3-story townhome for a 1-room cabin in the mountains. A week later, the buyer and seller signed a contract setting forth the even swap. In light of the apparent wide disparity in the values of the two properties, is the owner of the townhome obligated to fulfill the agreement because of his disparity? A, yes, if all elements of valid contract are present, the adequacy and equality of consideration are not critical to its validity. B, yes, because the townhome owner initiated the transaction. C, no, it was undue influence. D, no, it is an unfair advantage. Wow, this was a hard one. Not only to read, but to answer. All right, everyone, A. A is correct. Good job. So A, yes, all amounts of valid contract are present. Definitely know what makes a valid contract. All right, next question. Listing agent Jill notifies a client that she is bringing her an offer to consider from an MLS agent. On the way to the client's house, Jill receives a call from a buyer with whom she has an agency relationship. The buyer wants to see the listing and she agrees to meet him at the house. The potential buyer wants to make an offer and asks Jill to suggest a price that would be good to offer. Jill looks at the offer sent by the MLS agent and suggests that the buyer offer $500 more than the other agent's offer. Which statement is true? A, the listing agent has nothing to worry about. B, the broker should be proud of the listing agent. C, the listing agent did exactly the right thing for her client. D, when acting as a dual agent, the salesperson cannot suggest or recommend specific terms. Correct. It is D. Good job. The answer selections were pretty obvious here. Okay, good job, guys. Okay, Old Man Jones wants to settle his affairs prior to his death by selling his land and giving the money to his children. Broker Bob lists the property and markets it. After 6 months, an offer from Widow Smith, who lives in the next country, is received in the mail. Jones immediately signs the contract without change, and Broker Bob drives the next county to deliver a copy to the widow in person, which might prevent this from being a binding contract. A, Widow Smith's death before Bob can relate Jones' acceptance. B, nothing. C, Widow Smith is incompetent. D, either Widow Smith is incompetent or Widow Smith's death before Bob can relate Jones's acceptance. Wordy questions like this, you'll definitely find on your exam. Okay, we say B. All right, so it's D. Oh, that was a tough one. Death or incompetency of the parties may make it impossible to form a contract. Incapacity. Wow, I couldn't say that word. Okay, next question. A home buyer wishes to make an offer on a home but has little money. On the contract, they put down $0 as earnest money. Which of the following is true regarding the validity of the contract? A, the contract, when signed by the seller, is fully enforceable. B, the contract is not valid without earnest money. C, the minimum earnest money must be at least 1% of the offering price. Or D, even if the seller signs contract, the buyer is not bound to it. All right, good job. It is A. Earnest money is not required, but definitely a way to show like the good faith money. Earnest money, good faith money is another term for it. Okay, next question. Seller Sam decides to purchase buyer Bob's home. He submits an offer stipulating that the time is of the essence and the offer must be accepted in writing before 12 o'clock noon, 3 days hence. On the third day at 11:30 a.m., buyer Bob telephones seller Sam to say he has decided to accept the offer as written. Do the parties have a binding contract? No. A, no, acceptance was not made in the manner specified. B, yes, Sam cannot revoke the offer. C, no, buyer Bob didn't wait until noon to accept. D, yes, buyer Bob communicated acceptance to seller. All right, we're saying D. And it would be A. So no, acceptance was not made in the manner specified. If the offer specifies a particular manner of acceptance, the acceptance won't be effective unless those instructions are followed exactly. Until acceptance is communicated properly, in this case in writing, the offer can still be revoked, can still revoke the offer. Oh, that was a tough one. Since it was not in writing, that's the tricky part. That's why it's not a valid contract. He communicated it, but didn't put it in writing. A meeting of the minds refers to A, offer and acceptance, B, consideration, C, consummation of a contract, or D, closing of a contract. Correct. It would be A, offer and acceptance is the same thing as meeting of the minds. A listing agreement states the property will be listed starting today and the listing will terminate upon the property being sold. Which statement is true? A, the listing will lapse within a reasonable time. B, when the property sells, the broker will be due a commission. C, the listing is invalid as it does not contain a definite date of expiration. Or D, the buyer can determine when the listing will end. Oops. Okay, so you have two Bs. All right, so it is C. The listing is invalid as it does not contain a definite date of expiration. So in all listing agreements, you need to definitely put a date of expiration of the listing agreement. And obviously, when you see the listing agreement, you have to fill in that box. So, but knowing this for the exam is key. Okay. A buyer makes an offer. A buyer makes an offer subject to reviewing the results of a home inspection. After the inspection, the buyer is ready to move forward with the deal. Which does the buyer's agent need to do at this point? A, advise the buyer to renegotiate the purchase price. B, require the sellers make the recommended repairs listed on the inspection. C, prepare an addendum removing the contingency. D, recommend the buyer get an appraisal of the property. Okay, so we got D's and B's. Okay, so D. All right, so the correct answer is C again. Let's see. C. Prepare an addendum removing the contingencies. For every condition that is created in negotiations, an agent needs to document removing them when the time comes. When the buyer reviews the inspection report and is ready to move forward, the agent will prepare an addendum removing the contingencies. So another term for removal of contingencies is the ROC. So removal of contingencies is saying they're writing an addendum, and based off that addendum, they put specific things they would like repaired before moving into the property. Okay. Lauren receives an offer on her property and makes a counteroffer. Meanwhile, another offer comes in from another broker. The listing is A, pending, B, active, C, contingent, D, withdrawn. Oh, this is a good one to know. All right, we have A's and B's. Let's see, two A's. So the correct answer would be B, active. Only the seller can decide if she wants to withdraw the counteroffer and accept the new offer, or reject the new offer and hope the first buyer accepts her counteroffer. In any event, until the seller makes a decision, either way, the property is still available for sale. So once you make a counteroffer, a brand new offer is basically in place. So then that's sent back out to the buyers. And based on if the buyers accept or not, you're still waiting. So the property is still active. All right. Well, that was a good topic. I'm glad we went over that. And then I will get to law. We can always do contracts again. Okay, law. Where's the law? Okay. License law and rules of Ohio Real Estate Commission. All right, this one's 20 questions. A sales agent states in his advertisements that he will provide a free room addition to anyone who buys one of his listings. What is true? A, this is legal as long as this is noted on the sales contract. B, this is legal as long as the inducement is disclosed between the buyer and seller. C, this is unethical as sales agent may not offer anything as an inducement. D, this is unethical as the sales agent is not allowed to offer an improvement in real estate as an inducement. All right, that was quick. Okay, so the correct answer is this is legal as long as it's noted on the sales contract. This was a tricky one, but it is legal as long as it is noted on the sales contract. So a sales agent is not allowed to offer real estate improvements on real estate as a prize in a lottery or game of chance. When offered as an inducement, this must be noted in the sales contract and disclosed to the buyers and sellers. I remember I think when I was using CompuCrim to study, this was tricky, but definitely knowing as long as it's noted in the sale contract and then both parties agree to it, then it is legal. After recording an affidavit of lien with the recorder's office, the broker shall provide a copy of the lien affidavit where a contract for sale or other conveyance of the lien property has been entered into to the A, owner of the lien property and the prospective transferee. B, owner of the lien property. C, superintendent. D, prospect of the transferee. This is tricky. Okay, sounds good. All right, so we have A's. A is correct. Good job. So owner of the lien property and the prospective transferee. A buyer makes an offer on a property. The seller issues a counteroffer, which the buyer signed and selling agent delivered to the listing agent. The buyer passes a FSBO and likes it better. He makes an offer to the FSBO and the seller accepts. Which of the following is true? A, only the first contract is valid. B, both contracts are valid. C, the contract on the first house is not enforceable. D, neither contract is enforceable. We got A and C. Okay, so both contracts are valid. The buyer just purchased two properties. Both contracts are valid. Okay, next question. If the superintendent pays an amount from the recovery fund in settlement of a claim toward the satisfaction of a judgment against a licensed broker or salesperson, A, the license of the broker or salesperson is automatically revoked. B, the salesperson or broker must pay a fine of $2,500. C, there is no action against the broker or salesperson, as the fund is set up to protect the public. D, the license of the broker or salesperson is automatically suspended. All right, we got D, and D is correct. Good job. The license of the broker or salesperson is automatically suspended. Next question. Who approves the appointment of the ancillary trustee when a broker has died? A, division, B, Department of Commerce, C, probate court, or D, commission? All right, so C is probate court. So like any other estate, the appointment has to go through probate court, the court of jurisdiction over estates. So any question that you see with the word death or died, like the broker or the seller or the buyer, or actually probably not buyer, but the broker, the seller, or the listing agent, majority of the time, whenever someone passes away, the answer is going to be probate court. Okay. When lien automatically attaches to a commercial property to secure a broker's commission, oh, sorry, what lien automatically attaches to a commercial property to secure a broker's commission? Is that A, mechanics lien, B, judgment lien, C, attachment lien, or D, broker lien? Good job. Broker lien. They try to trick you by saying broker, but you guys didn't fall for it. Work. What is the maximum number of DBA, do business as, names a broker is allowed to operate under? Is that no more than five, B, no more than two, C, no more than three, or D, only one? We're saying D. So it is actually A. So a broker can have up to five business names to do business under. So no more than five. Upon the death of a licensed broker, what might occur? A broker within the business entity of the deceased broker takes over the listings. B, the superintendent appoints an ancillary trustee. C, the sales agent takes over the broker's listings. D, the Ohio Real Estate Commission appoints an ancillary trustee. Okay, unfortunately, probate is not in one of these. So the next best is we say D. So it would be A broker within the business entity of the deceased broker takes over the listings. So if is another broker, so if there are two brokers and one of them dies, the other broker is able to take over the listings. This was a tricky one because there's normally not two brokers, but in this case, there are. So a broker within the business entity of the deceased broker takes over the listings. All right. A homeowner is selling his house without the aid of a broker. The homeowner advertises that he will give anyone who buys his home two free airline tickets to anywhere in the continental United States. What is true? A seller is not authorized to give an inducement of any manner to an unrepresented buyer. B, this inducement must be disclosed on the sales contract. C, this inducement is in violation of Ohio Revised Code licensing law. D, this is perfectly legitimate and does not need to be disclosed on the sales contract. All right, D. D is correct. Good job. This is perfectly legitimate and does not need to be disclosed on the sales contract. Okay. When when must a broker record a written release or satisfaction of the broker lien in the county recorder's office in which the lien was recorded? A, the owner must file the release of a lien after the claim has been satisfied. B, within 10 days after the owner satisfies the claim. C, within 15 days after the owner satisfies the claim. D, within 90 days after the owner satisfies the claim. Okay, we got A's and B's. I think we have these first. Okay, so it would be B, within 10 days after the owner satisfies the claim. Definitely going, that is good to know. A person making an application to the recovery fund for payment must file an application to recover within A, there is no statute of limitations on a claim against the recovery fund. B, 60 days after the termination of all court proceedings. C, 1 year after termination of all court proceedings. D, 90 days after the termination of all court proceedings. All right, we got C, and that is correct. Good job. 1 year after all court proceedings. All right. If given the choice, what type of listing agreement would a seller probably prefer? A, net listing. B, open listing. C, exclusive right to sell. D, exclusive agency agreement. Okay, so we got B's and C's. And it would be actually D, which is never really used. So this is why they kind of tricked you. But D is when an exclusive right to sell agreement, a broker gets commission no matter who finds the buyer. An exclusive agency agreement states that if the seller finds the buyer, the seller saves the commission. That is not ever used really. So if given the opportunity, a seller of a listing agreement, the seller would choose exclusive agency agreement. But open listing is also a great guess. Okay. Who administers the real estate license law? A, Division of Real Estate. B, Department of Commerce. C, the police. D, Real Estate Commission. All right, so it is A, the Division of Real Estate administers the license law. So Division of Real Estate administers the real estate license law. This is tricky, their wording on it. When would a license be considered inactive? A, when the salesperson does not have a transaction within the mandated period of time. B, when the salesperson directs the broker to return the license to the division. C, when the broker dies. D, when the salesperson fails to turn in proof of CE. Okay, this is kind of tricky, but there is one that is the best answer. So if you don't do a transaction, you do not go inactive. When a salesperson fails to turn in proof of CE, this is bad, but what happens is your license is suspended. When the salesperson directs the broker to return the license to the division, they're asking to go inactive. So the correct answer is B. Inactive is a voluntary status that is initiated by the salesperson or broker. Failure to turn in proof of CE results in the license being suspended. So inactive is okay. It's basically you asking your broker that you want to put your license on inactive, so you can't practice real estate right now, or you don't want to pay for dues and things like that. So the salesperson initiates to the broker they want to put their license inactive. When you fail to do something that the state requires you to do, your license is suspended. Which of the following is not a management level licensee? A new salesperson. B, an associate broker. C, salaried licensed office manager. D, team leader. Okay, we got B and D. Correct answer is a new salesperson. Ohio license law considers any licensee who is in a position of supervision over another licensee is a management level licensee. So a new salesperson would not be considered a management level licensee. The others all manage people or teams. Okay. A broker offers a seller a free trip to Hawaii in return for a property listing. What is true? The buyer and seller must agree to this inducement. The broker must disclose this to any potential buyer. The broker must disclose this in the real estate sales transaction. D, the broker must disclose this on the listing contract. Okay, we say C and B. So it is D, the broker must disclose this on the listing contract. So if the broker offers a seller a free trip to Hawaii in return for the property listing, the contract they will present to the seller is going to be a listing contract. When you work with a buyer, that is a sales contract. When you work with a seller, that is a listing contract or exclusive, or it's the listing agreement or listing contract. And then purchase agreement or sales contract is with buyer. And in this case, you're working with a listing contract. A broker loses her license and there is no licensed broker to take over the broker's business. In this case, A, the sales agent may take over the listings. B, the sales agent may take over only those listings that are in contract. C, an ancillary trustee may be appointed by the superintendent to conclude the broker's business. D, the probate court must approve the appointment of the auxiliary trustee. Okay, we got CDC. Okay, cool. So the correct answer is C. So the probate court must approve the appointment of an auxiliary trustee only in the event of a death of a broker. Otherwise, the superintendent has the power to appoint an auxiliary trustee. All right, good job. That was a tough one. Under the Ohio Real Estate Recovery Fund, the commission shall impose a special fee not to exceed $10 annually on each licensee filing a notice of renewal if the recovery fund is less than A, 2 million, 2 million. B, the commission may impose the $10 at any time. C, $500,000, or D, $3 million. Okay, we have C and A. C was first. C is correct. It would be $500,000. All right, here is that breakdown of what that. This is the question rationale. Okay, next question. How many hours of continuing education are required by an Ohio licensee over a 3-year reporting period? A, 20 hours, B, 35 hours, C, 26 hours, D, 30 hours. D, 30 hours is. Okay, so sorry. So an agent wishes to specialize in the sales of commercial property. What should they do? A, choose best answer. Or sorry, A, find a broker that specializes in the sales of commercial property. B, stay with the same brokerage. C, must have done at least 20 residential transactions to sell commercial property. D, seek additional education in order to be licensed to sell commercial property. All right. Sorry, guys. Yeah, I was just talking to an agent was leaving my office. Okay. We have A, C, D, A, C, and D. I think A, I see A first. All right. All right. So the Correct answer is B, stay with the same brokerage. Ohio license law says there is no distinction between residential and commercial real estate from a licensing standpoint. An agent can continue to stay with their same brokerage and sell commercial as well as residential. Oh, okay, sorry, the question sounds confusing, but yes. We actually have a commercial branch in our office that an agent has taken over. So you can have a residential uh license and still do commercial properties. But that is its own contract and things like that. So definitely learning more about commercial contracts is going to be different. But you're able to stay at the same brokerage and also look at commercial properties and residential properties. All right. Good job. Let's see. Okay, so we did Ohio, we did law and we did contracts. Mm, Is there any other topic that you guys are struggling with, want to do? Probably time for one more. Let's see. We can do, right, let's do transfer of title. Okay, which deed is most preferred by the seller? Is that a quitclaim deed, B, a general warranty deed, C, a limited warranty deed, or D, a special warranty deed? So which one is most preferred by the seller? All right, good job. Oh, so actually it's a quitclaim deed. I thought it was B as well. Let's see. A deed that contains absolutely no warranties is a quitclaim deed. Subjects the seller to the lease liability. Okay, so a quitclaim deed is the most preferred by sellers. The general warranty deed must be desired by the buyer as it contains the four basic warranties: ownership, no liens, quiet enjoyment, and warranties forever. The limited warranty deed and special warranty deed are the same, and they give very limited or special warranties to the buyer for the time period during the seller owns the property. Got it. So buyers prefer general warranty deeds, sellers prefer quitclaim deeds. Definitely good to know on the test. Okay. Title to real estate is transferred when a deed is A, signed, B, delivered and accepted, C, acknowledged, D, recorded. We got B, and B is correct. Title to real estate is transferred when a deed is delivered and accepted. An instrument in writing that transfers ownership of tangible property is called A, blanket mortgage, B, bill of sale, C, listing, D, mortgage. So an instrument in writing that transfers ownership of tangible property is called a what? All right, we say B. That is correct. Good job. Bill of sales transfers only tangible property. Example of tangible property is going to be furniture. Perhaps the easiest way to remove a cloud on title is a quick claim deed, B, a quiet title action, C, foreclosure, D, eminent domain. Or we say A. A is correct. Good job. A quitclaim deed can be used by either a reported owner or a lien holder to release any interest held in a property. Good job, guys. A deed should be recorded in order to A, provide lis pendens, B, prove ownership, C, provide constructive notice to the world, C, provide actual notice to the buyer. All right, so it is C, provide constructive notice to the world. So an actual notice occurs when a person physically views public records. Recording the deed provides constructive notice, putting the buyer on notice to search the title of the property before buying. A lis pendens is a lien pending, and recording does not prove ownership, but rather puts a deed in chain of ownership. So this one would be a deed should be recorded in order to provide constructive notice to the world. Basically, recording it with the county. Okay, good job, guys. Thanks so much for joining.